next 2 minutes, direct my MA to be brought one.
Don't worry. Yes, Mr.
On section 21, I'll show only 2 sections, and last section is 36.
So 21 we saw.
Pardon me?
21 we saw, right?
The lordships have seen. Lord, I have already pointed out 21 why it is there. That you have to have some date to count limitation from. In this context, please see section 43. Subsection 4.
Yes.
May I read? Lord, can we have 43 subsection 4?
Yes.
Well, the title is Limitations. And 4, where the court orders that an arbitral award be set aside, the period between commencement of arbitration and the date of the order of the court shall be excluded in computing the time prescribed by Limitation Act. That is why 21, that there has to be some date from which you count the commencement.
So then what is the commencement there?
And 21 also says, unless otherwise agreed by the parties. So the commencement date is also a fluctuating date, can be decided by the parties. And 2 also, subsection 2 of 43. For the purposes of this section and the Limitation Act, an arbitration shall be deemed to have commenced on the date referred to in 21. Similar is the provision of section 9, subsection 2. Subsection 2, your lordship has, my lords. It has nothing to do with constitution of the tribunal, where before commencement of the arbitral proceedings, a court passes an order for any interim measure of protection under subsection 1, the arbitral proceedings shall be commenced within a period of 90 days from the date of such order. For this purpose, my lord, to compute the time from that date, it is, my lord, mentioned. Now, my lord, only section on which my learned friend Mr. Banerjee relied upon, section 34, my lord, please come to 34. Subsection 2, Roman 5, my lord, that was relied upon by him.
2A5.
2A5, sorry, I'm sorry, I stand corrected. 2A, subsection 5. The argument was, please read, my lord, first. The composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of parties. First, obviously, my lord, if it is not in accordance with the agreement of the parties, the award goes. 34 has this ground, my lord. Second, unless such agreement was in conflict with a provision of this part would mean part 1 applicable to domestic arbitrations, part 2 is international commercial arbitrations, with a provision of this part from which parties cannot derogate. Lord, I have already pointed out that section 12 is the provision from which you cannot derogate. You cannot exempt disclosure, 5th schedule, and ineligibility in the 7th schedule. And therefore, if arbitral agreement provides for any of these non-derogable part, then 34 will apply, my lord, and the award would be set aside. So this would never, my lord, help my learned friend in canvassing that there is any restriction to section 11.2. And I have been able to show to in my respectful submission that everywhere the thread is party autonomy, Now, quickly, my lord, I'll take your lordships to my written submissions, my lord. But it is volume 5A. My lord, some of the judgments which I have reproduced, I'll not read. But I respectfully request your lordships that it may be treated as read, but in some cases, I'll give the gist of what it says. Lord, your lordships may come to the bottom of page 35, Centro Trade. Your lordships have this?
Which part is this?
Part 1, part 2, my lord. Part 1, page 35. Arguments, submissions supporting one party having a neutral panel of arbitrators. Lord, ignore the title. Basically, there is no restriction, my lord, in having an agreement agreed to by the parties that the selection would be from one of the panel names. At the foot, my lord, clause 7, 5A, my lord, I'm sorry. Volume 5A.
Part 1 arguments.
Yes, my lord. Page 35.
Highway, page 36.
My lord, Justice,
Got it.
Justice Mishra, my lord,
Yes,
my
sir.
lord, sir. Lord, I am on clause 7. Your lordships need not read it. I'll just orally point out what the court held, my lord, in Centro Trade. It is essentially on party autonomy. My lord, this was a typical clause in a contract where, after an arbitral award, that award would be tested by another arbitral tribunal. The court said that it is odd, it is awkward, but nonetheless, we respect the party autonomy, and therefore, Lord, this was. Lord, kindly come to page 36. Lord, this judgment, my lord, in para 8. Lord, only highlighted part may be read, my lord, just to save time. Therefore, you have this paramount public policy to consider that you are not likely to interfere with this freedom of contract. My lord, this is said in the context of arbitration. So this I am relying upon to show that there can be an agreed clause providing for a panel. Now, Lord, page 37 bottom. Lord, Russell on arbitration. Lord, this para I would like to read, my lord. Further, your lordship gets, my lord, page 37 bottom, clause 14. Russell on arbitration states, further, where the agreement is a commercial agreement, it provides that an arbitral tribunal is to be constituted from a panel wholly appointed by one side. The party not involved in the appointment cannot seek to attack the award on the basis that the procedure would result in an impartial tribunal. The rationale for this is that it is common in commercial contracts that one party has little choice when it comes to the arbitration provisions, and where that party has agreed to the arbitration procedure, they must be taken to have waived any objection. However, the position may be different where non-appointing party is a consumer. My lord, now your lordships may come to 16. My lord, this judgment, this is, my lord, Wilson Taylor Asia Pacific Private Limited. My lord, this is the judgment of Singapore Supreme Court, my lord, authored by Justice Sundaresh Menon.
Yeah.
My lord, para 16, page 38.
Yes.
Yes, Lord, 16, Lord, part 4 of present written submissions, my lord. Lord, I'll take your lordships through page 65, my lord. No, not
They're taking us to the judgment itself?
the judgment, my lord. Yes, my lord. I'm taking your lordships to the judgment itself. I'm sorry, my lord. I'm a little slow in. Ashok, Lord, it is
Volume 3, page
volume 3, page 4591.
93.
Come again?
Volume 3,
Yes.
page 4591. I'll read only one judgment. No, I'm not reading other judgments. I'll just para 8. Lord, this is Supreme Court of Singapore, Lord, which your lordships would find at page 4589. And His Lordship, the Chief Justice, delivers the judgment at 4591. I'll read only 3 paragraphs. Para 8, my lords, have, my lords? Para 8, my Lord Justice Narasimha, Justice Adiwala.
Yes, got it.
The judge held, the impugn order is being discussed, the judge held that the clause constituted an arbitration agreement despite its asymmetrical nature. After an extensive survey of modern Commonwealth authority, the judge decided that a contractual dispute resolution agreement conferring an asymmetrical right, in other words, a right enjoyed by only one party to the agreement but not by the other, to elect whether to arbitrate a future dispute was nevertheless an arbitration agreement. Thus, he dismissed the respondent's argument that the clause was not an arbitration agreement because of its lack of mutuality. The judge also held that the fact that a contractual dispute resolution agreement granted the right to elect whether to arbitrate a future dispute was nevertheless an arbitration agreement. Therefore, the characteristics of optionality in a dispute resolution agreement was not inconsistent with the meaning of the nature of an arbitration agreement. Summing up these principles, he concluded that a contractual dispute resolution agreement which confers an asymmetric right to elect whether to arbitrate a future dispute is properly regarded as so and so. Now, please come to page 4593, para 13. Now, my lord, His Lordship's finding starts. Page, para 13.
There were two things. Only one party could seek arbitration. They upheld that. And second, in respect of a future dispute, arbitration was made optional. They said still it's an arbitration agreement.
Yes, well, slightly, my lord,
Slightly different.
no, different, but slightly, my lord, more stringent case than what we have.
It can be asymmetric.
Even arbitrability was also one-sided. Lord, para 13.
Arbitrability was one.
Not only the selection of whether to arbitrate was also subject to one party agreeing. Ultimately, I will point out, my lord, wherever any country wanted to prohibit, they have prohibited by legislation, by choice, that will not permit one-sided appointment. Otherwise, my lord, party autonomy is, we can agree that, all right, only one party will decide. Here, my lord, that's not the
There are
case.
instances where statutorily.
Yes, I'm coming to that. Yes, my lord, I'll assist your lordship with that. Lord, 13. In respect of the first of 3 requirements outlined at 11 above, we agreed with the judge and also the appellant that the clause constituted a valid arbitration agreement between the appellant and the respondent. It was immaterial for this purpose that clause A entitled only the respondent but not the appellant to compel its counterparty to arbitrate a dispute, the lack of mutuality characteristics, and made an arbitration of a future dispute entirely optional instead of placing parties under an immediate obligation to arbitrate their disputes, the optionality characteristics. On the weight of modern Commonwealth authority, which the judge considered, neither of these features prevented the court from finding that there was a valid arbitration clause between the parties, and before us, neither party contends otherwise. Now, my lord, coming back to my written submissions. My lord, as a matter of fact, apropos my lord Justice Narasimha's query, my lord, my lord, हमने कोर्ट जो किया है Lord, in yesterday, my lord, it was shown in uncitral model law, this restriction was suggested. My lord, I'll just, my lord,
You're right, but it was not specifically imposed because they said that two reasons they gave, three reasons.
few
That the existing provisions are adequate and that it would lead to ambiguity in the law.
correct, my lords. Your lordships are right, my lords. Now, Lord, kindly come to page 41. My lord, I can skip. They have already argued, my lord, my case, so I'm not. I have put both the sides, my lord, of the coin, but they have, my lord, started and put their part of the arguments. Some of the judgment, my lord, which I relied upon, are also, my lord, relied upon by them. Of course, my lord, I must be thankful to Mr. Banerjee that he said that he is reading from my judgment. That apart. Lord, now, my lord, I am on a page 57 for a very important issue. My learned friend Mr. Call read one blog of Jan Paulson. To satisfy your lordships, that unilateral arbitration clause is always to be frowned upon. My lord, your lordships recollects.
Yes.
Now, before I read this, my lord, let me clarify one thing, and this is where, my lord, I think inadvertently Mr. Call must have missed this. And I'll show, my lord, from his article itself.
Yes.
My lord, in international arbitration law, the word unilateral arbitration has different connotation. Wherever Jan Paulson, Lord, he writes, his concept, my lord, and this is, my lord, very crucial for deciding or for, my lord, understanding the blog which Mr. Call, my lord, heavily relied upon.
Yes.
Lord, Jan Paulson's understanding of unilateral arbitration is, I choose my arbitrator, other party chooses their arbitrator, and both of them choose the presiding arbitrator is unilateral arbitrator because we are choosing our own judges. And therefore, he is the proponent of the theory that arbitral tribunal has to be chosen by a neutral body. So he is not advocating institutional arbitration. He has been a proponent of institutional arbitration, that this system is wrong. That I select my choice of arbitrator, they select their choice of arbitrator, and both of them select one to preside over. That itself he treats as unilateral arbitration. And my lord, just my lord, to show my lord from his blog. But first, let my lord please read my lord page 57. Lord, this is my paraphrasing, but I'll read it from the article also. Lord, please come to, let me read from the article so that my paraphrasing may be objected to because it may have my color. Volume 4, page 3662. In my volume, my lords. My lord, this is the article they have cited. My learned friend missed the first 3 paragraphs.
In the same compilation?
In the same compilation, your lordships may find volume 4.
Volume 4.
Page 3662. There is a tab 26. My lord. So this is what Mr. Call relied upon.
Yes.
Let us read, my lord, first 3 paragraphs. First 2 also, my lord, would be enough. What is his understanding of unilateral appointment? Then he frowns upon it. What could, your lordship gets, my lord Justice Bhatwala?
Yes.
What could be more basic Arbitrations begin with each side naming an arbitrator. References are occasionally made to fundamental right to name one's arbitrator. But there is no such right. Moreover, if it is existed, it would certainly not be fundamental. The original concept that legitimates arbitration is that an arbitrator in whom both parties have confidence. It is quite unlikely that a party will have confidence in an unknown arbitrator selected by its unloved opponent. My selecting would not be trusted by him, his selecting would not be trusted by me, and therefore it should go to a neutral body for the purpose of constituting the tribunal. He is advocating that. Whether he is pitching it too high, maybe he is right. We do not know, my lord. I can't sit in judgment at the bottom.
No, just read the last paragraph of 3662 also.
Yes.
The common practice.
The common practice of unilateral appointments of co-arbitrators may be said to be popular in the sense of being perceived as a valuable opportunity on which parties insist. This seems clear from the frequency of explicit contractual stipulations to this effect, as well as from similar provisions found in rules devised by arbitral institutions. It may seem surprising to ask whether this is compatible with the very concept of arbitration. Yet, it is a serious question. It touches on a simple but a profound matter. The legitimacy of arbitration rests on the parties' confidence in arbitrators. There is every reason to doubt that the two main purported justifications for the practice of unilateral appointments are hardly convincing. It is said that one, even Homer nods and therefore three heads are better than one, especially when the stakes are high, and two, parties will have greater confidence in the selection of arbitrators selected for their special knowledge or skill. So he is talking about my choosing mine and he choosing his.
That's the next sentence.
Yet, each of these objectives may just as easily be met when all three arbitrators are chosen jointly or by an appointing authority.
This makes clear that what he's really driving at is that the arbitrator should be selected by a neutral arbitral instance.
Third party, not so.
And unilateral appointment is referred to in the context of unilateral appointment of co-arbitrators. One is
Yes,
by each of them.
one by me, one, and that
Not
is
where one party is appointed.
yes, then entire the meaning, context, and content of the entire blog would change if we understand Jan Paulson's understanding of what he means by the word unilateral appointment. Last para on this page. The only solution which will be reliable in all circumstances is that an arbitrator, no matter the size of the tribunal, should be chosen jointly or selected by a neutral body. This aspect of the process should no longer be misused as a sales argument for arbitration. Confidence enhancement is properly focused on procedural rights, the right to be heard, the opportunity, etc., etc. So, my lord,
So where there are unilateral, that arrow also, madam, very specifically deals with unilateral appointment.
yes, as understood by him.
Not so when there are unilateral appointments. It's obvious that a very different impulse is at work here. Introducing an adversarial element into the
of the arbitral tribunal, disputants tend to be interested in one thing only, a favorable outcome. They exercise their right of unilateral appointment like everything else with that overriding objective in view. The result is speculation about ways and means to shape a favorable tribunal, or at least to avoid a tribunal favorable to the other side, which is logically assumed to be speculating with the same fervor and towards the same end. Forgotten is the search for the arbitrator trusted by both sides. So he talks about unilateral appointments.
Lord, I can do one thing. Lord, Jan Paulson has written a book, An Idea of Arbitration. I'll supply that book. This is his understanding of unilateral arbitration. The way we conventionally, my lord, understand, I select my arbitrator, they select their arbitrator, and third person is presiding. That is his understanding.
But in any case, he is canvassing, as we understand, appointment of arbitrator by neutral institutions. That is what he is ultimately canvassing.
We are dealing with ad hoc arbitrations. We are not.
It's a view. It's just, it's a view of.
And it is a good view, my lord. It's a new institutional arbitration is always preferable. But that's not the issue before the court with ad hoc arbitration. This view, even if right, will not support the view that a panel is unilateral according to Jan Paulsen. Now, my lord, page 58, Gary Bond, my lord, I'll only read one line, my lord, because it is on the same principles, but for page 59. Lord, of course, these are all views. Ultimately, your lordships, in my respectful submission, will have to construe the act. Whether it
Anyway,
permits or
according to
prohibits.
Party autonomy is one golden thread which runs through the provisions of the Act.
Entire.
If the legislature intends to override party autonomy, that overriding the autonomy must be expressly set out and then indicated in such terms by the Act, which our Act has not done.
As under 12.5.
But only one para, page 59, third unnumbered para, highlighted part. Lord, unnumbered para 3 bond, I'm told it's considered to be an authority.
Yeah,
59, well, I rely on my friend, my lord, who has, my lord, the domain expertise. But page 59, although the issue is often, my lord, I have highlighted it. It's in bold. Although the issue is often highly fact-bound, most courts have upheld provisions in which one party provides a list of potential arbitrators from which the other party must choose an arbitrator. World over, this is global jurisprudence. The only condition is they should be neutral. They should not be my employees or related to me. In other words, they should not have the ineligibility contemplated under Section 12.
All right. What's next, Mr. Secretary?
Yes. My lord, limited scrutiny post arbitration, my lord, also, my lord, is one of the factors, because when I choose my arbitrator and they choose their arbitrator, and when there is no level playing field, my lord, in persuading the arbitrators, my lord, when we lose, when we suffer an award, my lord, there is, my lord, your lordship knows, my lord, what happens in 34, and rightly, for good reason. They have a right to decide wrongly also. We can't go into it unless some strict uh, uh, ground mentioned under 34 is made out. So this would disincentivize the arbitration as a mode of dispute resolution. Therefore, my lord, limited scrutiny of 34 may also lead, my lord, to an inference that kind of a neutral body that is not connected with me, what my lord, American court says, intrinsically connected to one party, like my managing director, my consultant. But now I'm not reading. But there is one judgment, and I would strongly, but I'm not reading it right now because of lack of time. Lord,
What
there
is said, the limited ground, so far as the.
Lord, limited ground.
So therefore, that's the ground for challenge.
Lord, just to ensure that please approve a contract which I am permitted under 11.2, that from my neutral panel, they will select. They will not select as per their choice. So that 34 virtually is an illusory remedy. Well, that's the submission. Well, there is one. Lord, I'll not read one judgment, but I would strongly recommend that all my lords may read this judgment, my lord, because of lack of time, I'm not reading it. It makes a very interesting read. The Honorable Court, my lord, it's an American judgment, has, my lord, its Board of Education of Berkeley versus W. Harley Miller. Lord, it is a part of our written submissions, my lord, dealing with asymmetrical clauses like this, that one party having a dominant right.
Where did you mention about that?
Yes,
Just
Uh,
the page, that's all.
page 1670.
The written submission,
I'm sorry, 1668. I'm sorry, 1663. It starts.
in the precedence compilation,
Yes, no, our compilation. Our compilation, volume 5. Lord, why?
yeah, 165,
It starts 1663 at 1670.
It's PDF 1665.
I'm great.
1670, okay.
I'll read 2 paragraphs and rest your lordships may read it. It makes an interesting read. It ultimately concludes, my lord, what I am respectfully urging for your lordship's consideration. But the way in which the judgment is written, my lord, makes an interesting reading. The basic problem, my lord, somewhere, lord, right-hand side column, second paragraph from the bottom, my lord, your lordship gets the basic problem.
Page 1670,
1670, my lords.
right?
Right-hand side column, second para from bottom. The basic problem, your lordship, my lord Justice Padiwala again. It's very interesting, my lord. I have read it fully, but your lordships may read it at leisure. The basic problem in all arbitration cases could probably best be explained not in terms of legal characterization such as condition precedent, ousting courts of their jurisdiction, or revocability, but rather by a hypothetical case in the tradition of ancient fabulist Aesop. Let us assume for a minute that for some reason all rabbits and all the foxes decide to enter into a contract for mutual security, one provision of which were that the dispute arising out of the contract would be arbitrated by a panel of foxes. Somehow, that shocks our conscience and it doesn't help the rabbits very much either. Now, what happens if we have the same contract with the same arbitration provision, except that disputes will be arbitrated by a panel of wolves? Is there such a community of interest among foxes and wolves that the wolves cannot be impartial? Possibly. Now, what happens if the dispute will be resolved by a panel composed by one squirrel, one elephant, and one wolf? One might conclude that squirrels look like rabbits, wolf look like foxes, and elephant ought to surely be, etc., etc. But eventually, it says that elephant will surely be impartial. Then animal law becomes procedurally very complex. I'm not reading it, but it ultimately reaches a conclusion that this unilateral in the way in which we use it is not illegal. Go to Lord, please come to Lord, last 2 points, and I know your lordships are looking at the
No,
watch.
you are just on something, just,
Okay. Otherwise, I can ensure your
it's
lordship.
been a long day of work, we have to have some pleasantries also.
I understand, my lord. But so long as your lordships are looking at the watch, there is no difficulty. I promise my lords will not be required to look at the calendar.
But here, the example, the rabbits will jump and the fox will trot.
An elephant is treated to be a neutral, obviously, because he doesn't look like either of them. Squirrels resemble rabbits and foxes resemble wolves.
Can I just
Yes, your lordships are right. Well, that's the word. But 65, kindly come to page 65. My Lord Justice Narasimha, my Lord,
of
this
the
question.
written submissions, no?
Yes, my Lord. my written submission 65, part 5. Asymmetrical arbitration agreements in different jurisdictions. But first two, my lord, in global context and present context, my lord, would be relevant because globally it has different shades, my lord. Asymmetrical has different meanings, not the way, my lord, we understand it. My lord, first, global context. Lord, kindly come to the table directly, my lords. Please come to page 65. Lord, there is a table given. My lords have.
Yes.
My lord, the purpose is to show that whichever country wanted to expressly prohibit one party to provide for a panel, it is so prohibited statutorily. And there is an exception made to the autonomy, party autonomy. Lord, Netherlands, for example, your lordships may kindly, Lord, remember the color scheme, Lord, the legend. Green is permissible and the other color is impermissible. Lord, kindly see the underlined portion. This is, my lord, the statute in Netherlands, Dutch Code of Civil Procedure. Your lordship gets, my lord, that page.
Yes.
If the, my lord, I'll read, my lord. My lords are taking.
Yes.
Page 65, my lord, Netherlands, the statutory prohibition. We don't have, my lord, I'm not repeating. If the arbitration agreement, I'm reading the underlined part, this is the statutory language. If the arbitration agreement gives one of the parties a privileged position with regard to the appointment of the arbitrator or arbitrators, the other party may, despite the method of appointment laid down in that agreement, request the provisional relief judge of the district court within 1 month after commencement of the arbitration to appoint the arbitrator or arbitrators. So the law does not permit, or rather leaves it open for the other side to not agree, even if agreement is providing. And next is Germany. Similar, my lord, I will not read it. Same, my lord, it is same. Page 66. Third is Spain. Spain, my lord, page 66.
Yes.
Article 15.2 of Spanish Arbitration Act. Please see 2, subsection 2. The parties are able to freely agree on the procedure for the appointment of the arbitrators, provided that there is no violation of principle of equal treatment. In the absence of any agreement, the following rules shall apply. Lord, my learned friend wants to read 18, which is an equal treatment by the arbitrator in 11.2. This is how 11.2 could have been if the legislature so intended. I hope, Lord, I am able to make myself clear. 11.2 would have been in this manner if they wanted 18 and 11 to be read together. Then your lordships may, my lord, come to page 67, again Spanish, my lord, subsection 6. Not necessary. Lord, kindly come to 68. Estonia, Lord, section 721(2) of Estonia Code of Civil Procedure, Lord, para 2, subsection 2. If an arbitral agreement gives one of the parties in the formation of an arbitral tribunal an economic or other advantage over the other party, which is materially damaging to the other party, such party may request that the court appoint one arbitrator or several arbitrators differently from the appointment which already took place or from the rules of appointment agreed upon earlier. Clear statutory mandate that you cannot have this. It is derogable. You can agree, other side can agree, or they go to the court. Poland, same. Russia, same. I'm sorry, Manoj, Your Lordship. Well, may I assist Your Lordship with any section, Manoj?
The argument was that a similar provision is made in 11.8. 11.8 implicitly recognizes that. That is what
11.8, Manoj.
11.8.
But-
Other considerations as are likely to secure the appointment of an independent and impartial arbitrator.
Yes, Lord, but 11.8 kicks in. So please, Lord, allow me to repeat a little while. Please see 8. The arbitral institution referred to in subsection 4, 5, and 6.
No, the unamended provision is in footnote 2 at the bottom.
Yes, Manoj.
The Chief Justice of India, the person or institution designated by him in appointing an arbitrator shall have due regard to A, the qualification, and B, other considerations as are likely to secure the appointment of an independent and impartial arbitrator.
Yes, Manoj.
So therefore, their argument was that when the court exercises the power, you are not hidebound by,
The court is not bound, but that's not, Lord, my argument.
court is not bound.
But 11, Lord, when a party goes to the court, Lord, when the party would go to the court under 8, in case of the contingency stipulated under 6, please see 6.
Then the court has a wider power.
No, Lord, I'm saying something slightly different. 6, kindly see 6. 8 comes only when we reach the court. We reach the court only if 6 contingency arise. Please see 6, Lord. Where, Lord, the same page, Your Lordship, where under an appointment procedure agreed upon by the parties. So 11.2. A, party fails to act.
There's a failure of that procedure.
Then only we reach Your Lordship. So that does not take away 11.2. That confers an additional power
That point of view.
on the court. My Lord, page 69 and 70. Lord, I'm on the last point.
Yes.
Lord, last point, page 69 and 70, I have said that Singapore permits such a clause, asymmetrical clause. Britain permits such a clause, asymmetrical clause. But that again is not a decisive factor. The point is, whenever legislature wanted to restrict, it has done so by statute.
We have to construe our statute more than anything.
That's, my Lord, the end of the matter. My
Thank
Lord,
you.
last point.
Yes.
Last point, my Lord. And I would, my Lord, really oblige, my Lord, if your Lordships can consider this, my Lord, this is directly linked with this. Please come to section 12. My Lord, this is the provision, not a very popular thing to urge, but still, my Lord, it is necessary, my Lord, at times to urge to ensure that the object is achieved. My lord, 11(1)(b).
B.
Sorry, 12(1)(b). This is my last point, my lords. Your lordship's yawn is more vocal, my lord, than your lordship's words. But this is my last point, my lord, I can assure your lordships. When a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstances. B. But I'm entering into a little unpopular area, which are likely to affect his ability to devote sufficient time to the arbitration, and in particular, his ability to complete the entire arbitration within a period of 12 months. Lord, this is observed in breach. My learned friend, my lord, says 100% breach. My lord, we are ad item. My lord, Mr. Banerjee is also. So, no, my lord, I am fortified by.
All prove.
Now. No. Why I said.
Part 4 are notified. See, the solution to that is to have an arbitration council in place.
I'm
Council in place, it will do all.
Give me a minute.
All objectives.
Give me a minute more. Why I raise this in this matter? Lord, whenever there is a panel, and I'll give the list of panels, I don't wish to argue, just to illustrate. The panel gives the name of the arbitrator, other details, his qualifications, experience, etc., and the number of arbitrations that particular arbitrator is doing, so that the other party can choose that this arbitrator is doing 9 arbitrations. He may not be able to devote time to my problem, my dispute. So better I will go for some other arbitrator. My lord, I'll give that. Number 2, in ICC, whenever an arbitrator is approached, not only ICC, other institutions also, Lord, arbitrator is called upon to give his 2 years calendar. We have placed that on record. My lord, I'll give the page 1975. Lord, it is the list. I know it's not a.
What you are making is what we are saying.
Lord, what has happened is.
The spot has being responsible. Because specifically a 43D, we have provided the duties of the council, which will be to formulate timelines, to formulate accreditation, to call for information, how many arbitrations are pending before each. Put it up, all that on the website. Everybody will know how many arbitration each arbitrator holds. What is the timelines? These are the requirements. Now, all of these are ad hoc arbitrations. So even assuming that they are ad hoc, some institutionalization or some kind of a regulation must happen.
Lord,
That was the purpose and object of the council.
Well, I always say.
What your concerns are reflected here under 43D, subsection 2 to
Correct.
K, L.
But my lord, B 12A 1B also says within 1 year, and there is thereafter 6 months extension. But 29A, my lord, I only on the lighter side say, my lord, before arbitrators, that arbitrators are now comparable, and it is on the lighter side, but nothing derogatory, with film stars in 2 ways. We always listen that we couldn't get the dates of this particular stars, therefore we have to appoint. My lord, it's very difficult to get dates. My learned friend would agree. Very difficult. Today's date will go after 3 months, 4 months. And second, film stars operate in 3 shifts. So do arbitrators. Morning shift, afternoon shift, and night shift. It's good, my lord. There is nothing wrong about it.
Did you say
But
3 shifts or 3 screens?
Lord, that is
Just
I bow down. I bow down, my lord. I could say only 3 shifts, my lord.
I was not saying anything.
He was just wondering whether he heard screens or shifts.
My lord, the lawyers do that, my lord. That I can vouch for, my lord. We have been witness. The lawyers, my lord, are hearing from more than one screen.
Unless we shift into This
Legal
now,
arbitration.
ad hoc arbitration is an unorganized sector.
It is.
It's an unorganized sector, there is no regulation.
Whenever, my lord, in
So unless we shift into a
my lord,
situation
in
of.
institutional arbitration, this factor is considered. For example, Sarod, my lord, we have a Sarod arbitration. It is considered that this learned arbitrator has more than what can be done within 1.5 years. But 12 months, 6 months extension, but thereafter we survive on 29A. Court keeps on extending. And that's, my lord, the hard reality, my lord, the ground reality. And, my lord,
Why didn't notify the, the provision and bring that into existence as an institution?
12(1)B says, my lord, that he has to
We're not
disclose.
answering that question with the
Why
Chief
is
Justice
the
asking.
government not notifying?
What's the concern?
Can be, my lord. I'll, my lord, consult the government, and, my lord, it can be, should be notified.
Notify it immediately.
Certainly.
And you passed an act, right, for the other one? Indian, what is that act called?
That's part of this amended and included in this very chapter.
My lord, but
Headed by Justice Hemant Gupta.
my lord, would it still, my lord, I'm posing a question to myself, dilute 12(1)B, that you have to complete by 12 months, you have to disclose whether you will be able to complete within 12 months, and extendable period by consent is only 6 months. I leave it at that. Well, so far as, my lord, NBFCs are concerned, well, last point.
Mr. Solicitor, what we have done is my learned two judges, brothers, Justice Padial and Justice Mishra, we must have appointed, I think, about 25, 30 young lawyers as arbitrators in this.
That's a better way. You know, that's,
in the
but
smaller
otherwise,
claims
my lord,
of-
I
not necessarily smaller claims, but
no, certainly, my lord, my learned friend, my lord, but my lord, your lordship.
that's the Bombay High Court in winding up matters.
Yes.
Ultimately, it's not about winding up a company, small claims. By consent, we'd appoint arbitrators and not retired judges, we would appoint young lawyers, juniors at the bar who would be
And
appointed.
they are doing it very enthusiastically and within the time. But, my lord, I flagged it, my lord. I don't wish to be more unpopular on this argument, my lord. Therefore, I leave it at that. But 12(1)B is a mandate, and there is no consequence of non-compliance with that mandate. Lord, so far as NBFCs are concerned, but there are certain institutions like railways, non-banking financial companies, where they deal with thousands of cases, thousands of arbitrations. Lord, they will, by the very nature of their function, when I enter into an agreement for taking loan of, say, 2 lakhs or 3 lakhs, I know that there is a different bargaining power. They are taking a greater risk. Something which I cannot borrow from the bank is being borrowed from NBFCs. So I agree to a particular arbitrator. Otherwise also, my lord, take for example a person who has taken a loan of 3 lakhs. My lord, I'm posing a question to myself, do we really expect him to go in search of an arbitrator? He finds an arbitrator who is ready to work as per Schedule 4 fees, etc. And, my lord, deal with the NBFC.
Most of the smaller claims proceed ex parte, actually.
Yes, but
The lawyers appointed
to
by the
that,
bank.
my lord, there is a solution I am suggesting.
Credit card.
My lord, I have a solution, my lord, which I have placed on record. My lord, there is a solution on record. My lord, there is a, my lord, page SAMA, my lord, it is called SAMA. One example, there is one example. There is an institution which does online dispute resolution. That's the best thing, my lord, for small, my lord. SAMA stands for समझो मगर प्यार से. That's समझाओ मगर प्यार से. That's, forget the name, my lord. They could have chosen a better name. It's called SAMA, and, my lord, this is at page 1983, volume 5A. Lord, please come to only for a second. Lord, this may perhaps be a game changer. Kindly come to page 2000, my lord, volume 5A. Only a minute, my lord. This may be a game changer, your lordship would.
Yes.
really contribute something, my lord, would be able to contribute something. Page 2000. My lord, this is one organization. Volume 5A, page 2000. It is recognized by the High Court, Government of Maharashtra, Bombay, Ministry of Justice, Union of India, etc. But its advisory council is former Chief Justice, Justice Sri Krishna, Justice Kannan, etc., etc. But this is online dispute resolution for small people. And the award comes within 45 days. Not expensive, no major, my lord, delays. I have placed, my lord, on record their entire activity. And this is recognized by many. Many banks have joined this for their small depositors or small problems. The loan agreements of smaller loanees, my lord, have a provision that dispute will be resolved by this. My lord, this, I think, is the solution for smaller depositors. We are not on big sharks, my lord, that's all. Obliged to, Lord. I'm grateful, my lord. I exceeded my time, my lord, but I'm grateful.
Now we go to Mr. K. M. Natraj. Yes, Mr. Natraj. Over and above what the solicitors argued, now what is the point that you are making?
Volume 5C, morning I forwarded my short written argument. So both on behalf of the court, that is the petitioner in the main matter which has been referred to the Honorable Court, and also I am representing IAC, that is Indian International Arbitration Center, which is an intervener. Representing both in the matter.
So what is the substance of it?
Yes.
You can just summarize.
Yes. May I kindly have my short written note, which is at volume 5C.
Yes.
So reflecting on the screen. I'll try to finish as early as possible without repeating any of the points which has been raised by learned solicitor.
Can you tell us, just formulate what is not
the first one is
argued.
the party autonomy, which is the basic feature of the arbitration, which for a different purpose I am putting it, for the purpose of analyzing the very reference and the issue, which is the basic feature of the arbitration proceedings.
Your second bullet point is correct. That
Yes,
7.6 arises only if any of the situations provided in A to C are not fulfilled.
Secondly, there is no statutory bar on either of the parties, either independently or jointly, appointing an arbitrator. There is no statutory bar. Either of the parties can independently, one party can appoint an arbitrator, or jointly by virtue of some kind of agreement, jointly they can appoint. That is recognized and ingrained in section 11(2) of the Act, which is party autonomy. If that is the case, when there is a statutory bar, party autonomy has to be respected, and which is further fortified by section 11(6). Finally, take section 11(6), which again speaks of the agreed procedure.
Submissions.
Yes, under 11(6), it further fortifies the party autonomy for appointment to evolve any kind of procedure to be adopted by the parties, either individually or independently. And again, section 12 also recognizes and fortifies such a right.
Yes.
By keeping in mind, two things will have to be considered. One is both appointing authority or appointing person and the arbitrator are two independent and distinct entities. And their identity is different. Appointing and acting are two distinct roles.
All right. Next, what is the next one?
They are distinct roles. If they are distinct roles, the statutory prohibition is only for the purpose of the acting as an arbitrator, not for the purpose of appointing. The law does not prohibit any kind of restriction insofar as appointing authority is concerned.
Yes, next.
The appointing authority can appoint, and the impartiality or the neutralities that is attributable only to the arbitrator appointed and acting as an arbitrator.
All right. What is the next one?
If that is so, now what is not provided under the statute that need not be read into,
No limitation.
no limitation
Yes.
prescribed under the act.
No limitation can be written by implicit.
Yes. And the omissions, even if it is an omission, that cannot be supplied by interpretation.
All right. Anything else?
These are in support of that 4 judgments I have also placed, including the wisdom of the legislature, upon which once there is no embargo on the person who can appoint, then there is nothing more to be said about it. And 2 things: in TRF, the situation was totally different. TRF, that the arbitrator himself was the managing director himself was an arbitrator, and also he was supposed to appoint. In that context, it was said so in the TRF case. And here in the second, this reference by Justice Nariman and the 3 judges bench in Tantia, kindly see that reference itself is totally may not be appropriate. This one reference, kindly see how it has been referred in this one in volume 1, page number 3. It presupposes something which is not otherwise provided under the act. Kindly have a reference at page number 3.
Volume 1, page 3.
Yes. Everything is on the arbitrators, not on the appointing authority. So therefore, there is nothing to read something relatable to the appointing authority. I'll leave, please.
Natraj. Now we will hear Mr. Arvind Kamath.
All right.
Mr. Kamath, apart from what has been argued, what would you like to say?
Yes, my lord. I represent the BMRCL, which is the Bangalore Metro Rail Corporation. Now, I'm purely on the issue of the maintenance of the panel system. Now, I've got
The maintenance of
the panel by one party.
Right.
Purely on that issue. Lord, I've got 5 propositions stroke principles to be placed before Lordship.
Tell us, formulate.
And Lord, the first one is that the contractual conferment of a right to form a panel of arbitrators is a commercial bargain.
One second.
But I'm saying the contractual confirmation of a right to form a panel of arbitrators is a commercial bargain, and it falls within the purview of party autonomy under Section 11(2) of the Arbitration and Conciliation Act. Lord, every commercial contract is a result of a commercial bargain. Lord, parties are free to bargain their rights, provided it is consistent with law and public policy.
What is the second point?
The second point, my lord, is that enlisting of the names on a panel does not per se constitute appointment. Lord, I enlist the names only for the purpose of administrative exercise. My lord, merely because I add the names on the list of potential arbitrators, there is no conferment of any rights, nor does it entail any remuneration. It does not even guarantee a right to be appointed. It is only obtaining prior consent.
Third point, Mr.
My lord, the third point would be that, my lord, yesterday we saw the perception-based challenge to the procedure of appointment is not sustainable in law.
One second.
Lord, every strand of argument.
Just 1 second. Perception-based challenge
to the procedure of appointment of arbitrators from a panel maintained by one party is not sustainable. Lord,
One second. From a panel maintained by one party. By one party, what? Is not sustainable.
Is not sustainable. Lord, yesterday we saw, Lord, argument like, for instance, there is an economic incentive to pass an award in favor of the party who maintains. Lord, it is based on perception. Lord, the allegation that I curate a list, Lord, is based on perception.
Fair enough. What is the fourth point?
Lord, the fourth point would be that there are statutory safeguards to ensure independence and impartiality of the empaneled arbitrators. And it's a 4-tier, the statute has laid down a 4-tier mechanism. And those 4 are Lord, I'll quickly enlist the 4. Lord, number 1 is the insertion of section 12(5) as well as schedule 5 and 7.
Yes.
Lord, number 2 is the mandatory declaration, Lord, which is a consentious declaration. It is akin to an oath by a judge.
Mandatory disclosure.
Mandatory disclosure under section 12.
Third?
Lord, the third is, Lord, the statute provides a challenge. Just in case, Lord, an unconscientious decision is made by the arbitrator, it gives a right to the party to challenge him.
Okay, that's a
And Lord, fourth is that if there is a challenge made and if it is declined, that gives a ground to challenge the arbitral award. So which means there is a judicial review of the decision of the arbitrator that there is no bias. And both those arbitrators appoint the presiding arbitrator. So which means it's a very fair principle.
Thank you.
Therefore, I'm breaking down, Lord, the formation of the panel should be divested from the way the panel operates. The formation of the panel, my lord, it's a contractual right. But how the panel operates, my lord, Voestalpine has laid down the principles. So therefore, my lord, to summarize, maintenance of a panel by one party is not following on the sole ground that Tantia doubted core. Not the learned single judge should not have, learned single judge should have followed core.
Well, thank you.
I'm grateful.
You've rendered very valuable assistance, very well formulated.
I'm grateful,
Thank
Raj. I'm
you.
grateful.
Yes, now, 1 second. Now, we will, Mr. Guru Krishna Kumar.
I'm in 501.4, my lord.
Yes, Guru. What's the formulation?
My lords, broadly, four points, my lords. In fact, my submissions, I'll put it as propositions and leave it at that, my lords.
Number one.
One, while adopting, my lords, the submission on behalf of the Solicitor, by the Solicitor General, my lords, that the statute per se does not bar unilateral appointment of arbitrators. I adopt that. While adopting that, I want to make this formulation. The exercise of power under section 11(2) of the Act, my lords,
1 second.
is conditioned by section 12 of the Act. Because the language used in 12 is anybody invested with the authority to appoint before the appointment has to get declaration from the prospective candidate. Which means, therefore, my lords, please see the language for a minute, my lords. Just have a look at that. CC 12, when a person is approached in connection with this possible appointment as an arbitrator, he shall disclose in writing any circumstances, then A, B, etc. Then please see the second explanation to 12 minutes. 12 after B. The disclosure shall be made by such person in the form specified in the 6th schedule.
All right.
So this is one. Therefore, bodily, my lords, 12 and Schedule 5 and Schedule 7 have to be read into 11(2). That's one, my lords.
Yes.
Second point, my lords. Mutuality, which seems to be the premise on which, my lords, there is reliance on 18. There are three.
Mutuality.
Mutuality is the premise on which, my lord, section 18 is being invoked and sought to be read into the appointment process. Now, for that, I have 3 submissions, my lords. Number 1, that does not take note of the fact that 18 is a general provision in the next chapter, whereas 11 is a provision specifically for appointment. And the legislature has consciously, my lords, not brought in that principle in 11.
Next.
Third point, my lord, assuming 18 can be invoked by some basis, mutuality will have to be understood, my lords, in the business setting and the fact setting of the parties' transactions. Arbitration, my lords, is at the end of the day a consensual arrangement for adjudication of disputes other than through the court process. Therefore, the business setting and the background of the transactions will have to be understood. There cannot be an omnibus stand that unilateral appointments cannot be resorted to at all. And to contextualize this submission, my lords, I want to talk about my NBFCs. The Solicitor General referred to it in the passing. I am representing an NBFC. I have a claim for a few lakhs of rupees. In fact, in this very case,
Yes.
the party does not respond to the notice for appointment. I go ahead, appoint the arbitrator, award is granted. The award is sought to be executed by me. At that stage, Perkins is taken note of by the execution by court by itself, and, my lords, the award is held to be a nullity, and the whole thing is set aside. I've come against that, my lords.
All right.
Now, therefore, this is the second point, my lords. Business setting has to be understood. In fact, the fact that business setting is a factor in legislation, please.
All right,
make a note.
1 minute. Huh?
One-
You have to- Yes, you have to complete the
There,
other.
my lords,
Next.
the next point is, my lords, the nature of, my lords, the transaction and business setting, it is given importance, my lords, in the statute itself. For that, just please make a note of explanation 2, schedule 7 and